Hello everyone, welcome to yet another educative and inspiring video on Global Justice Talk. Global Justice Talk is a channel that values fairness and justice in society. My name is Uraya Chikwetu. I am a lawyer or attorney based in Harare, Zimbabwe. Today's video is a video that I promised when I discussed one of the grounds for divorce in Zimbabwe, that is, in which I discussed irretrievable breakdown of marriage as one of the grounds for divorce. If you haven't watched that video, I have provided the link in the description box below. Today's video we are going to discuss one of the grounds for divorce, that is, the defendant is suffering from mental illness or is in continuous unconsciousness. I have promised to discuss this ground for divorce in our previous video as indicated. But before I discuss this ground for divorce, I encourage you to subscribe to our channel and also to like, comment and share this video with your friends, so that YouTube can show this video to a larger audience. It's very important in that the moment this video is shared with a larger audience, a lot of people will become enlightened on issues to do with the family law and in particular divorce law. Thank you so much for doing that. For those who have already subscribed, I am highly indebted and for your kindness. So let's move on to discuss our ground for divorce today. That is what is meant by incurable mental illness or continuous unconsciousness of one of the parties for the marriage. In terms of Section 6, subsection 2 of the Matrimonial Causes Act, an appropriate court may grant a decree for divorce on the grounds of mental illness or continuous unconsciousness if it is satisfied that the defendant is suffering from mental disease or mental defect and is under care and treatment for a continuous period or interrupted periods, which if aggregated amount to at least 5 years within 10 years immediately before the commencement of the divorce action, and that the defendant, by reason of physical disorder, is in continuous unconsciousness, which have lasted for a period of at least 6 months immediately before the commencement of the divorce action, and that there is no reasonable prospect that he or she will be cured or gain consciousness. So basically, this is the meaning of the ground for divorce, to the effect that the defendant is suffering from mental illness or is in continuous unconsciousness. But from this discussion, you can pick that there are some terms that are used in this provision. We are referred to the concept of care and treatment, and I'm going to expound on those. But before I do that, I once again encourage you to subscribe to our channel and also to comment, share, and like this video, so that YouTube can share this video with a larger audience. What is meant by under care and treatment? We find this in Section 6, subsection 4 of the Matrimonial Causes Act. According to Section 6, subsection 4 of the Matrimonial Causes Act, a person shall be deemed to be under care and treatment while he or she is detained in pursuant of an order or warrant under the Zimbabwean law or the law of another country related to mental disorder, or while receiving treatment as a voluntary patient under the said law. So basically, that is the meaning of under care and the treatment in terms of the Matrimonial Causes Act. So it is very important for you to be able to understand this before you file your divorce action. Then from the discussion of this ground for divorce, you may think that it is very easy for you to get an order of divorce for the asking. You cannot just get this order so easily. There is need for some evidence for the court to grant you this order for divorce based on this ground. So what evidence is supposed to be shown for the court to grant you an order for divorce on the grounds of mental illness or continuous unconsciousness? According to Section 6, subsection 3 of the Matrimonial Causes Act, an appropriate court shall not grant an order for divorce on the grounds that the defendant is suffering from mental illness or is in continuous unconsciousness, unless it is satisfied by the evidence of at least 3 medical practitioners, of whom 2 shall be psychiatrists appointed by the court, and these medical practitioners have testified that indeed the defendant is suffering from mental illness or is in continuous unconsciousness. So basically, this is the meaning of mental illness or continuous unconsciousness. You can be granted an order for divorce if you are able to demonstrate what I have discussed here. In other words, you need to show that the defendant is suffering from mental illness, and they have shown evidence of the period over which the defendant has been suffering from mental illness. You would also want to show that the defendant is suffering from physical disorder, which have lasted for at least 6 months immediately before you file your divorce action, and the evidence from medical practitioners is supposed to be shown, and also that the defendant has been under treatment and care, and you are able to demonstrate that to the court, then the order for divorce can be granted. So thank you so much for watching the video. But before I go away, I want to encourage you to subscribe to the channel, and also to like this video, comment and share, so that YouTube can show this video to a larger audience. Thank you so much for watching. But I also want to emphasize that the discussion we have here is not to be taken as the legal advice. If you have got a burning issue related to this ground of divorce, I encourage you to visit a legal practitioner, so that you can get a specific legal advice to your specific situation, so that you get proper advice. Thank you so much for watching. I encourage you to continue watching this video and other videos on this platform concerning the matters of law. Thank you so much.